Welcome to this video. Today's topic is Delegated Legislature in India. What is the meaning of delegated legislation? Delegated legislation exercises legislative power by an agent who gains a lower rank in the legislature or is subordinate to the legislature. Delegated legislation is one of the most controversial topic in legal theory of India because it has its number of implications in different sectors. The three pillars of Indian democracy that can be assigned as the legislative, the judiciary, and the executive. According to the Constitution, the legislative body has the power to make the laws, while the executive branch has the power to implementation of that legislative laws, while the judiciary has the authority to settle the disputes and administer justice. Now we will come across through the delegated legislation and its significance. It provides a mechanism to delegate certain legislative functions to the executive, allowing for efficient implementation and administration of laws. Delegated legislation also ensures that laws are made by individuals or bodies with specialized knowledge and expertise in specific areas. Delegated legislation have some certain powers. The legislature can respond more quickly and efficiently to changing circumstances and emerging issues. Our next topic is Indian context of delegated legislation. According to Black Laws Dictionary, it defines delegation as the act of entrusting a person with power, or empowering him to perform on behalf of the person who has provided him that power as to serve as his agent or representative. Here, the term delegated legislation refers to the exercise of legislative power by an individual who is lower in status than the legislature or subordinate towards the legislature. Delegated legislation is also termed as the auxiliary legislation, as the act made by someone or something other than the parliament. Now, according to the Act of Parliament, Parliament can give power to another person or body to enact legislation. An Act of Parliament establishes the system of a single or particular law and usually includes a description of the Act's aim. By delegated legislature from Parliament to the executive or to the other subordinate, different people with different organizations are empowered to incorporate in those specific tasks, and subordinate legislation also comes we will go from any power is other than the sovereign between the delegated legislation and the administrative law in India. According to the Indian context, the constitutionality of administrative regulation should be debated through distinct periods ranging from the Privy Council to the current apex court, that is, the Supreme Court of India. The Supreme Court of India established legal norms on various judgments that currently serve as a guideline for any delegation to fall into being either constitutional or unconstitutional in nature. We will go through some important case laws on this context. In the Indian Oil Corporation versus Municipal Corporation Jalandhar, the Supreme Court determined that any delegated law shall be compatible with the Parent Act. Thus, it should not violate any legislative policies of such. To be more specific on this background, the court hinted that the delegate is not expected to have more legislative authority than any other delegate. The Supreme Court clearly states that motivation for delegated legislation is not a good basis for determining the author's competence. Rather, the court would consider the relevance and significance of the context and background in which the rule-making power was exercised. Historical concept of delegated legislation. The history says that delegated legislation power is linked back to the Charter Act of 1833, when East India Company came to reclaim their political influence in India. The Charter Act of 1833 placed administrative powers solely in the hands of the Governor-General in Council, an official body. He had the authority to enact laws and guidelines for cancelling, correcting, or alternating any laws or guidelines that applied to all the individuals regardless of country. The Government of India Act 1935 was passed in this year, including a serious delegation scheme. The Committee of Ministers' Power report was submitted and confirmed, which settled the case for force assignment and appointment of enactment, which was considered necessary in India. Now, the main question is, the Indian Constitution contains almost 400 articles, and it is not surprising that the Constitution's authors included a remedy for it. But why were these provisions included in the Constitution? This is due to the tendency of politicians in the Constituent Assembly to multiply legislative formulations compared to the other major constitutional concerns that were bypassed by the Assembly and were left to future consensus or judicial interpretation. These topics were of modest significance on which legal formulation was made. What are the criticisms are faced by the delegated legislation? It is often said that the lack of accountability or transparency in the whole lawmaking process, and which leads to any kind of concentration of powers in the executive body, and this undermines the principle of separation of powers. Also, even it is said that the ordinances must be approved by the legislature,